Welcome to EPG Pathshala. I am Dr. Anand Raut and today we will be discussing on capital punishment. Capital punishment is one of the forms of punishment. Maintenance of law and order has been one of the primary functions of state. State prescribes law which provides punishment for committing offences. One of such punishment is capital punishment or death penalty. The term capital is derived from Latin term capitalis, meaning head, referring to the execution by beheading. Capital punishment is said to be justified only in extreme cases in which high degree of culpability is involved, causing grave danger to the society. While awarding capital punishment, personal attributes of the convict such as circumstances in which the offence was committed, the gravity of offence, etc. are taken into consideration. It is often suggested that capital punishment should be given only when the option of awarding the sentence of life imprisonment is unquestionably foreclosed. Death sentence has been used as an effective weapon of retributive justice for centuries altogether. But on the other hand side, death punishment as a form of corporal punishment has also been criticized for being violative of certain basic human rights. Article 3 of Universal Declaration of Human Rights 1948 states that everyone has the right to life, liberty and security of person. Article 2 of European Convention for the Protection of Human Rights and Fundamental Freedoms 1953 contains similar provisions on the protection of the right to life. The UN Human Rights Council has also adopted resolutions on the prevention of death penalty. In 1984, the UN Economic and Social Council adopted safeguards guaranteeing protection of the rights of those who are facing death penalty. In 1989, UN General Assembly adopted the second optional protocol to the International Covenant on Civil and Political Rights that gave abolition decisive new momentum. Member states which became parties to protocol agreed not to execute anyone within their jurisdiction. UN General Assembly resolutions. In a series of resolutions, different resolutions were adopted in 2008, 2010, 12 and 2013 by General Assembly. In these resolutions, General Assembly urged the states to respect international standards that protect the rights of those facing the death penalty, to progressively restrict its use and to reduce the number of offences which are punishable by death. It is interesting to note here that in 2007 December, India voted against the United Nations General Assembly resolution calling for a moratorium on the death penalty. In November 2012, India again upheld its stance on capital punishment by voting against the UN General Assembly draft resolution seeking to end the institution of capital punishment globally. Now, let us examine various theories on punishment under criminal law. Punishments under criminal law are the solutions to the injuries suffered by the society due to crimes. These punishments may be classified either corporal or non-corporal. Corporal punishments are those which are inflicted on body, such as incarceration, whipping, forced labor, flagellation, caning, flogging, branding, even mutilation or death. Punishment of death is practiced in India. Examples of non-corporal punishment take the form of fines, suspension, deprivation of civil rights forfeitures, and so on. These punishments are based on different theories. The different theories of punishments are as follows. First theory, deterrent theory. This theory aims to deter the offender from being part of the society as his acts or omissions are threat to society. Deterring the offender also serves the purpose of setting a lesson in the society that certain acts and omissions are condemned. Grave offences definitely deserve deterrent punishment. This may include imprisoning the convict for life. Second theory is retributive theory. This theory is based on the principle of eye for an eye and tooth for tooth. Theory justified by its advocate that it satisfies the feeling of revenge in the victims and their near ones. Advocates of this theory also urge that the theory makes the offender realize the pain which he inflicted on others. On the other hand, the theory has also been criticized being inhuman and brutal. The theory is also criticized on the ground that feeling of revenge will increase hatred in the society and will negate the chance of reformation in the offender. Death penalty comes within the ambit of this theory. Third theory is preventive theory. This theory revolves around the principles that prevention is better than cure, the offender being prevented from the society so that the offense itself is averted. The next theory is reformative theory. This theory believes in reforming the offender rather than just punishing him. No one is born criminal, and circumstances surrounding him are responsible for turning a person into an offender. If such a person is given proper education, rehabilitation, counseling, then the offender may be transformed into a better law-abiding citizen. This theory is more human and has received many accolades. This theory gives the offender to lead a respectable life in society after reformation. Next theory is expiatory theory. This theory states that if a criminal repents of the offense committed by him, then he may be forgiven and may be set off. Based on the above given theories, punishments are the provisions of criminal law in India, prescribing various forms of punishment such as imprisonment, forfeiture, fine, solitary confinement, capital punishment, etc., etc. But among all these, capital punishment is highly debated question form of punishment. Let's have a look at the history of capital punishments. Capital punishment has always been awarded in grave offences. The modes of inflicting capital punishment were varying. For example, capital punishment was awarded by boiling the convict to the death, beheading, burning, stoning, strangling, shooting by gun, etc., etc. In 18th century before Christ, Code of King Hammurabi of Babylon prescribed capital punishment for 25 different crimes. In 10th century BC, King William inflicted death penalty in times of war. In 1655, Duke instituted a new law in New York prescribing capital punishment for certain offences. In China, human trafficking and serious cases of corruption are punished by death penalty. Now, let us have a look at the scenario governing capital punishment in India. Traces of capital punishment may be found in the Indian epics of Mahabharata and Ramayana respectively. Capital punishment in Islam is regulated by Sharia law, which is the religious law of Islam. The ancient lawgiver Manu also supported death penalty. According to him, death penalty was necessary in order to refrain people from sinful murders. Death penalty was practiced in Mughal era also. During early decades of 19th century, various modes of inflicting death penalty were abolished, and under the British regime, a British system of criminal justice administration, capital punishment was legalized by Indian Penal Code 1860. The prescribed mode of punishment was death by hanging. Execution of capital punishment has always been a topic of debate. According to Article 21 of Indian Constitution, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Whether state has the right to take the life away from a person is still a subject of contention. The first hanging in the independent India was that of Nathuram Godse and Narayan Apte in Mahatma Gandhi assassination case. Since 1991, 26 executions have taken place. After independence of India till date, more than 170 people have been hanged. According to the statistical data released by National Crime Records Bureau, the death penalties awarded between 2004 and 2013 is as follows. Uttar Pradesh, most number of death sentences, that is 318 were awarded. Second was state of Maharashtra with 108 sentences. Third was Karnataka with 107, Bihar with 105, Madhya Pradesh with 104. These top 5 states awarded almost 57% of all capital punishments in the country between the year 2004 and 2013. As per the research carried out by National Law University, Delhi on death row convicts, since 2000 it has been found that 1,617 prisoners sentenced to death by trial courts in India, the capital punishment was confirmed only in 71 cases. Now, let us discuss instances of death punishments in India. In the past decade, 4 executions have been carried out which have grabbed headlines in media. First, Dhananjay Chatterjee. Dhananjay Chatterjee was accused of raping and then murdering a 14-year-old girl. Second, Ajmal Kasab. Ajmal Kasab was a part of terrorist group who were responsible for 26/11 attacks in Mumbai. Third, Afzal Guru. Afzal Guru was accused of being mastermind behind the attacks on Indian Parliament dated 13 December 2001. A special court was formed under the Prevention of Terrorism Act which sentenced him to death. Next is Yaqub Menon. He was accused of taking part in sponsoring the 13 serial blasts in Mumbai in the year of 1993. In India, capital punishment is carried out by hanging the accused by the neck till the person is alive. Now, the question rises that whether there has been a set parameter on which death sentences are awarded. Judiciary through catena of judgments have developed a principle of rarest of rare while awarding death punishment. In India, death punishment is prescribed for murder, robbery, abetting suicide, etc., etc. Death penalty can also be given to repeat offenders under Criminal Law Amendment Act of 2013. Capital punishment is awarded in India if it is within the ambit of rarest of rare case, as we have earlier discussed. The Supreme Court has categorically laid down in catena of judgments that punishment must be given in rarest of rare cases only. In Bachchan Singh versus State of Punjab, which is one of the landmark judgments on capital punishment, the constitutional bench judgment of Supreme Court of India made it very clear that capital punishment in India can be given only in rarest of rare case. Honorable Court was convinced that it ought to be very sparingly inflicted, and it proposed to employ it only in cases where either murder or the highest offence against the state has been committed. In another case, famously known as Machi Singh and others versus State of Punjab, Honorable Supreme Court upheld the death sentence of the accused on the ground that murder committed by the accused was exceptionally depraved and heinous in character. While at the time of deciding this case, the apex court realized that the rarest of rare cases has caused inner conflict in the minds of judges, because it leaves too much confusion in the mind of judges to decide whether the case falls within the rarest of rare case or not. And hence, court discussed 5-point formula based on the manner in which the murder was committed, the motive, the manner in which the personality of the victim has taken shape, etc., etc. If the offence was committed with extreme brutality, such as cutting body into pieces or burning the victim alive, it would be a fit case to be considered as rarest of rare case. When the motive reveals meanness of the murderer, for example, crime committed for material gain. When murder is socially offensive, loathsome, such as bride burning, etc., etc., then it needs to be punished with capital punishment. When the murderer has committed multiple murders, or when the victim is innocent child or a helpless woman or reputed figure. The court declared and cautioned that these guidelines should not be applied too literally, giving a wide scope for the discretion to the courts in deciding whether death penalty should be given or not. In Rajendra Prasad versus State of UP, Honorable Supreme Court of India stated that it is the duty of the court to impose a proper punishment depending upon the degree of criminality and desirability to impose such punishment as a measure of social necessity, as a means of deterring other potential offenders. Failure to impose a death sentence in such a grave cases where it is a crime against the society, particularly cases of murders committed with extreme brutality, will bring to naught the sentence of death provided by section 302 of the Indian Penal Code 1860. To allow the appellants to escape with lesser punishment after they had committed such intentional, cold-blooded, deliberate and brutal murders will deprive the law of its effectiveness and will result in the travesty of justice. Another landmark case on death penalty is the case of T.V. Vatheeswaran versus State of Tamil Nadu. Supreme Court in this case reiterated that prolonged delay in execution exceeding 2 years might be a sufficient ground to quash the death sentence, since it is unjust, unfair and unreasonable procedure, and the cause of delay is immaterial, and the person under the sentence of death may also claim fundamental rights. Here, Supreme Court recognized rights of a prisoner and even a prisoner who is on its death row. If unreasonable delay has been taken place while punishing a prisoner, or while executing its death sentence, then it may become a ground for him to not execute him. Article 14, 19 and 21 are not mutually exclusive, is what Supreme Court has discussed in this case. They sustain, strengthen and nourish each other. They are available to the prisoners as well as free men. Prison walls do not keep out fundamental rights. A person under sentence of death may also claim fundamental rights. The fiat of Article 21, as explained, is that any procedure which deprives a person of his life or liberty must be just, fair and reasonable. Just, fair and reasonable procedure implies a right to free legal service where he cannot avail them. It implies a right to speedy trial also. It implies human conditions of detection, preventive or punitive. Procedure established by law does not end with the pronouncement of sentence. It includes the carrying out of the sentence. That is as far as we have gone so far. It seems short step, but a step in the right direction to hold that prolonged detention to await the execution of sentence of death is unjust, unfair and unreasonable procedure, and the only way to undo the wrong is to quash the sentence of death. Thus, Supreme Court recognized human rights of prisoners on death row. Now, let us have a glance of the laws or provisions which prescribes capital punishment in India. The first law which we will discuss, which prescribes capital punishment in India, first is Section 121 of Indian Penal Code. Section 121 prescribes death penalty for waging war against Government of India. Another is Section 132 of Indian Penal Code. Section 132 penalizes abetment of mutiny in armed forces. Then Section 194 of Indian Penal Code, or famously known as IPC, the Chief Penal Code, it punishes for giving or fabricating false evidence leading to procure a conviction of capital offence. Then famously known as section for murder, Section 302 of Indian Penal Code penalizes accused if it is proved that he has committed murder. Section 305 of Indian Penal Code penalizes or prescribes punishment of death penalty for abetting the suicide of a minor or insane person. Section 376 of Indian Penal Code and by Criminal Law Amendment Act 2013 is penalized with death punishment if the perpetrator has inflicted injuries that results into victim's death or is a repeat offender. Section 120B of Indian Penal Code provides for death penalty to a person who is a party to a criminal conspiracy to commit a capital offence. Then Part 11, Section 4 of Prevention of Sati Act 1887 penalizes for aiding or abetting an act of sati. Section 31A of Narcotic Drugs and Psychotropic Substances Act 1985 penalizes drug trafficking in cases of repeat offences. Then there is Bombay Prohibition Gujarat Amendment Bill 2009. In Gujarat, manufacture and sale of poison, alcohol which results into death is punishable with death penalty. One of the another provisions of Indian Penal Code which prescribes for death penalty is Section 396, which prescribes death penalty for committing murder coupled with dacoity. The Scheduled Castes and the Scheduled Tribes Prevention of Atrocities Act 1989 was enacted to prevent the commission of offences of atrocities against the member of scheduled caste and scheduled tribes. Under section 3 clause 3 clause 2 subclause 1 of the act, bearing false witness in capital case against member of scheduled caste or tribe resulting that person's conviction carries death penalty. In 1989, Narcotic Drug and Psychotropic Substances Act was passed, which applied mandatory death penalty for a second offence of narcotics trafficking. One of the highly debated factor with death penalty is the mode in which the death penalty is executed. The mode of death penalty of execution of death sentence has been varied in different parts of world. Different modes of execution are practiced in different countries. Mode of execution of death penalty in India is governed by section 354 clause 5 of Code of Criminal Procedure 1973, which states that when any person is sentenced to death, the sentence shall direct that he be hanged by the neck till he is dead. The constitutional validity of this mode of execution was challenged in famous case of Deena versus State of UP on the ground that it was violative of Article 21 of the Constitution of India, being inhuman. Article 21 of the Indian Constitution protects right to life with dignity of person. The Supreme Court rejected this, and it was held by the Supreme Court that hanging a person is a less painful mode of executing the death sentence and upheld the validity of the relevant section under the Code of Criminal Procedure Code. The Code of Criminal Procedure 1973 henceforth will refer it as Code, further requires that the sentence of death imposed by Sessions Judge can be executed only after the confirmation from the High Court as per the section 366 clause 1 of the Code. The Code also contains a special provision regarding death sentence. Section 354 clause 3 of the Code indicates that when the conviction is for an offence punishable with death sentence, the special reasons must be given for such sentence. Army Act 1950, Navy Act 1957, Border Security Force 1968, Indian Coast Guard Act 1978, etc. provides the death sentence may be executed by hanging till death or by being shot to death. So, these few laws provides a different mode of execution. Let us discuss what opinion Law Commission of India holds upon capital punishment. Through its various reports, Law Commission of India has given its opinion on the execution of death penalty and related issues. India is one of the 59 countries where death penalty is still awarded by the courts. The 35th report of Law Commission of India, published in 1962, scrutinized the issue of capital punishment in India. The report had recommended the retention of death penalty. Then Law Commission of India, in its 42nd report published in June 1971, suggested that children below the age of 18 years should not be sentenced to death. It is not necessary to exempt women from death penalty was also stated in that report. An attempt to suicide should cease to be an offence in India, and the present law should be replaced, was suggested by Law Commission. Later, in 187th Law Commission report, it was focused, the focus was on mode of execution of death and incidental matters, and the report discussed deliberately upon the mode of execution of death penalty. The report restricted itself to three issues. Number one, the method of execution of the death sentence, the process of eliminating the differences in judicial opinions among the judges of the apex court in passing the sentence of death penalty, and third, the need to provide a right to appeal to the accused to Supreme Court in death sentence matters. In 2015, Law Commission published 262nd report on death penalty. The report favored abolition of death penalty and made following prominent recommendations. First, provision for police reforms. Second, witness protection scheme and victim compensation scheme should be taken up expeditiously by the government. Death penalty be abolished for all crimes other than terrorism related offences and waging war. There is a huge debate surrounding whether there should be death penalty or not. Death penalty as a corporal punishment has been a topic of debate and has attracted a lot of hue and cry. There have been arguments in favor of it and against it. Both needs to be analyzed. Arguments in favor of capital punishment are made by retentionists. Capital punishment is based on retributive theory of punishment which aims to satisfy vengeance. Capital punishment may instill the fear in the minds of criminal, and a strong message can be set on behalf of entire society that certain crimes deserve punishment nothing less than capital punishment. They also support capital punishment because it might prevent overcrowding of prison and is more economical, as no costs or expenses for detaining the prisoner for longer period of time. Heinous and grave offences deserve capital punishment. On the other hand side, there are arguments made against capital punishment. Abolitionists think that capital punishment may result into great injustice to the person who is wrongly sentenced to death. There are possibilities of miscarriage of justice in such situations. It is also criticized as being violative to human right, as it denies chance for reform in convict. In India, there is a set of law which governs capital punishment and clemency. Clemency powers are vested with Honorable President of India under Article 72 of Indian Constitution, which states that President can grant pardon, suspend, remit or commute a sentence of death of any person convicted of any offence. However, the President does not exercise this power on his own, as he has to act on the advice of Council of Ministers. Once a convict has been finally awarded the death sentence by the Supreme Court, anybody can send a mercy petition to the prison office pertaining to that person. Section 235, clause 2 of the Code of Criminal Procedure Code calls upon the court, providing that the convicted accused must be given an opportunity of being heard on the question of sentence. This provides a chance to the accused to place his social or economic background before the court. On the issue of delay in deciding mercy pleas, the Supreme Court in landmark judgment held that the death sentence of condemned prisoner can be commuted to life imprisonment on the ground of delay on the part of government in deciding mercy pleas. Let's have a look at the contemporary debate revolving capital punishment in India. There are various reasons because of which capital punishment in India has been a topic of debate. Few amongst them are the quality of judgments awarding death sentences, existence of poor quality of representation to marginalized sections, corruption in law enforcement system, overburdened judiciary, lack of quality legal aid, under-resourced prison system, resulting into lack of information to the death convicts about the legal process, etc. To voice the concerns of persons on death row, the Center on Death Penalty at National Law University, Delhi released Death Penalty India report in 2016. The various kinds of information presented in the report raised issues which were integral to the discussions on the death penalty. Following are the statistics released in the report. The female prisoners sentenced to death state-wise is as follows: Delhi 3, Maharashtra 3, Uttar Pradesh 2, Chhattisgarh 1, Haryana 1, Karnataka 1, Madhya Pradesh 11. Another statistical data that was released in the report included the ratio of prisoners sentenced to death in each state in comparison with the population of that state. The number of prisoners was in ratio with per 10 lakh population of that particular state. There are various states that you will find in the table with the number of prisoners who were awarded death penalty and the ratio per population, 10 lakh per population. There is another statistical data relating to the occupation of death convicts. In the table, the various occupational categories can be witnessed with the number of prisoners sentenced which belong to that occupation category. The report raised crucial questions concerning access to legal representation and its quality, which are just as integral to understanding the mechanics of death penalty in India. The report observed that the burden of the death penalty falls disproportionately on different marginalized groups considered along axis of class, gender, caste, religion and levels of educational attainment. The report also said that it would be grossly inaccurate to argue that there is direct discrimination in the operation within the criminal justice system. Report states that one person in conflict with the criminal system often means that there is a ripple effect that ends up deepening the social and economic marginalization of family members. Thus, summarized, after going through all the dynamics and the existing laws and the cases governing death penalty, that the main object behind imposing death penalty is to deter the offender and also to create a fear in the minds of person who may dare to commit such heinous offences. In India, capital punishment can only be given in rarest of rare case. As per the various guidelines given in the catena of judgments by the Supreme Court, the rarest of rare case is to be decided, and then the convict is sentenced to the death. Before giving death sentence, the session court has to confirm it by the High Court as laid down in section 366 clause 1 of the Code of Criminal Procedure. The convict also have the executive remedy to file a mercy petition to the President and Governor under Article 72 and Article 161 of the Constitution of India respectively, wherein the President have the clemency power to grant pardon. While awarding capital punishment, socio-economic status, education, gender, number of dependents in the family, intention, etc. of the convict may also be considered. Thank you.